All right, welcome back, everybody. So as I said, we're switching over from Robert Durst because now it's time to talk about Harvey Weinstein. Harvey Weinstein is a defendant we've been covering a lot here on the Law and Crime Network. We covered his sex crimes trial out here in New York when he was convicted of 2 major counts. And now we are talking about the fact that out in L.A. he faces an additional 11 charges. Well, maybe not 11 anymore because one of the charges has been dropped. Law and Crime's Brian Buckmeyer has more.
There was no merit to count 5.
The judge officially dropped count 5, which accused Weinstein of sexual battery by restraint against a woman in May 2010. That brings the number of accusers in the indictment down to 4.
We expect that the defect in the prosecution's case on all the counts and all the Jane Doe's allegations are going to be revealed.
Weinstein was initially charged in January 2020. 6 months later, he was indicted by a grand jury. Judge Lisa Lynch ruled that prosecutors had not informed the grand jury that in those 6 months, the allegation had fallen outside the 10-year statute of limitations. Prosecutors disagreed.
This superseding indictment that we've obtained in this case is a continuation of everything that we've done before.
David Ring represents one of Weinstein's Los Angeles accusers. She testified at the grand jury proceedings, and Ring says she's prepared to testify again when Weinstein goes to trial.
She's hanging in there. It's been tough. It's been a long haul, and it's she's still very fearful of Harvey Weinstein, and she's very anxious about the process, but she is going to see it through.
Okay, let's talk about this. Judge, I know our time together, well, we still have you for a little bit longer, but I know we only have you for an hour, so I want to jump into this. Is this a big win for Weinstein? One of the charges dropped?
Well, I would suggest to you that anytime the defense gets a case dismissed, it's a good thing for them. This is a statute of limitations dismissal. Doesn't mean it did happen. It doesn't mean it didn't happen. It's nothing about a judgment on the merits of the allegation itself. Simply put, it's just that the allegation, even if it is true, happened outside the time limit to prosecute those types of cases. Every state has different statutes of limitations for different crimes, and even if this one happened, it happened outside the statute. So that's it. Case dismissed. He's still looking at 10 other charges. He's still sitting on a 23-year prison term. So maybe he won the battle, but the war is still yet to be fought.
And Julie, what about those 10 other charges? Is there a chance he could get any of the other ones dropped as well?
I mean, anything's possible. It doesn't look like it because none of them, seem to fall outside of the statute of limitations. I will add one thing is, even though the judge has dismissed this case, it is possible, just like what happened in the Harvey Weinstein case in New York, that the judge would allow in that testimony if it in some way assists in the modus operandi, like the identity, the type of crime, the way he committed this crime. So it is possible that the judge would let it in anyway to enable the jury to have a better understanding of the other crimes. I don't think he will, just because I think the prejudice would outweigh the probative, but certainly that is a possibility.
Well, Judge, let me ask you your perspective on this, the idea of allowing other evidence in. We've seen it before in New York. It becomes a question in other cases. Happened in Bill Cosby as well. If you were a judge on these kinds of high-profile cases where you have the option to allow in other testimony that a defendant wouldn't be charged with, but as this kind of supporting evidence for the prosecution, would you allow it?
Well, first of all, you can't treat this case any different than you would treat any other case. There's no exception for high-profile cases versus, just regular cases where the media is not involved. What you have to do is you focus on the indictment that is being presented to the jury. And from that indictment, that's the foundation for everything else. And what may be inadmissible at the beginning of the trial may be admissible later on if one side opens the door or the way the case is being tried and defended. It can be all the way up until the jury closes that some of these other charges will come in. You do have to be careful. What you're trying to make sure is that you don't have to try the case more than once. Got to be conservative, I would say. You don't want to let other crimes in. That is ripe fodder for an appeal. But the law does allow for it, and as Ms. Rindeman said, there is no statute of limitations for this extraneous conduct. So you have to watch the trial as it unfolds. And the question is always, is it relevant for an issue that is different than the character of the accused? Is it relevant because it goes to intent or mode of operation, lack of accident, mistake? All of those things will allow extraneous conduct to get in, but you got to be very, very careful as a judge.
Now, obviously, the judge allowed one of these charges to be dismissed, but did not allow or did not request the defense's motion to dismiss the other charges. Take a listen.
Okay, thank you both very much for good arguments. I think that the indictment does have to allege the tolling information. So I'm going to sustain the demur on count 5 with leave to amend, and the people can proceed as they choose to proceed, and I'll deal with whatever choice they make.
We'll file an amendment today.
Okay. With respect to counts 6 and 7, the demur is overruled. I do believe that Perez is controlling and good authority. I do believe it was either Perez or Anthony that discussed the legislative history, different legislative history than that cited by the defense, but nonetheless cited the legislative history of wanting to make serious offenses have a longer tolling period or statute of limitations, not tolling period. So I'm going to overrule the demur on counts 6 and 7.
Okay, Julie, let's talk big picture. You're looking at Harvey Weinstein, and obviously, you know, it's impossible to know what he's thinking, but where does this trial value to him in terms of his overall life? Because the question becomes, and I get asked this all the time, you know, why is the LA trial so important? I always say it's important because you have to give these victims, these alleged victims, their chance in court. These are actual alleged crimes. You can't just ignore it because of what happened in New York. But from a strategic legal point of view, you have read everything about what the appeal is that his team is making here in New York. Is there a chance that he could get some sort of, his convictions overturned here in New York, very similar to Cosby, and then now he has to deal with LA? And so it's the idea of, you know, if you're the government and you're thinking, well, you want to keep Harvey Weinstein behind bars, whatever issues might happen in New York, that's one thing. Now we got him in LA. It's like a second bite at the apple. Is that one way to be thinking about it? I'm curious your perspective.
Absolutely. I mean, he has to keep in mind, and we all have to keep in mind, is even if they were successful in the New York case, it's not the same as Cosby. He would be retried because it's not, the issues are completely different at the end of the day. And so if they were to determine, for example, that the judge allowed in too many outside bad conduct in order to make out the cases, then at the end of the day, the case would be retried and those pieces would be removed. It would be a harder case for the prosecution, but nevertheless, there's no question they would go forward. Obviously, if he's convicted in LA, he now has 2 issues with 2 potential appeals, and he has to be successful with both of them to the point that they don't retry him again, or when they retry him again, he's found not guilty. And so he recognizes that, you know, any successes in LA or avoiding any conviction will potentially help him if, in fact, he's able to, his case in New York results in an acquittal at some point if there's a retrial.
All right, well, we're going to talk more about Harvey Weinstein, clearly a very big, high-profile case that we've been covering here on the network. But we're going to take a break. When we come back, we're going to talk about another case that we had been following for the past few weeks, the Stephen Wiggins trial. We'll be back.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTube TV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTube TV today, and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTube TV. We put you in the jury box.